and believe the Fourth Geneva Conventions apply. What the Fourth Geneva Conventions require is entirely unclear because they have not been, outside of the context of Israel, clarified in any other context. So we know what they mean for Israel, but we don't know what they mean elsewhere. Now, this is not the view of the entire international community. For example, the United States has made clear that the West Bank is not occupied, which would clearly mean that the Fourth Geneva Convention does not apply and the question of settlements does not apply. It is likely that there are other countries that may be sympathetic to this position, but are unwilling to face the political costs of making it clear, which are easier for the United States to absorb. And as a matter of first principles, it's very hard to understand under international law itself, rather than people's opinion of international law, how there can be an occupation, because this was neither the territory of Jordan, rather it was territory to which Israel had a sovereign claim. And even the famous memo of the United States State Department legal advisor, which in 1977 concluded that the area is under occupation because while it didn't belong to Jordan, it was Jordan's enough. That memo also said, less famously, that if Israel were to make peace with Jordan, all occupation would end and all questions about the settlements would thus end. Israel, of course, made peace with Jordan in 1994. It's a full peace, and there is no instance in the world of a situation of occupation existing after a peace treaty.
Thank you. Pnina, please.
So I think that, first of all, the situation, there's no clear-cut legal answer. People presume that there is, but it is a complex issue, and there are, I agree, very little precedence to the situation here. But I think when it comes to occupation or belligerent occupation, my view is that it is a factual situation. So since Israel took control of the West Bank and the Gaza Strip and other areas, but I'll focus on the West Bank, during an armed conflict, even though it was on the defensive there, but still, and it controls it ever since, so it is controlled under the rationale of belligerent occupation, and this is also the rationale that Israel applied. It applied the Hague regulations, for example. It stated that it views them as valid, and it also used them to carry out different authorities based on these regulations. With regard to the Geneva Convention, or the Fourth Geneva Convention, the situation was more complex, or the Israel's position is more complex, but again, because of the wording of Article 2, not so much because of a dispute about the fact that it is under belligerent occupation. However, I think the next question is, even if it is under belligerent occupation, that doesn't necessarily mean that it belongs to the Palestinians. I think the rights of the Palestinians are derived from their right for self-determination. That is a right that has been developing in the second half of the 20th century. So there's also a question about historically whether it was a valid right when Israel took control of the territory. But even if we respect it, it doesn't necessarily mean that all of the territory belongs to the Palestinians, because the Green Line is not an official border, and it was even written in the disarmament agreement with Jordan in 1949 that it is not a border. So I think there's a dispute here about exactly how to what should be the final status of this land that should be negotiated between the parties. And therefore, I think that when we look about the legality of settlements, it is more a political, or it is more related to the laws of belligerent occupation that refer to the rights of the previous sovereign, which we don't have. So it's more linked to the political aspects of occupation, and therefore, I'm not sure that the legal arena is the right one to discuss that. On the other hand, when it comes to the rights of Palestinians, here I think they are protected persons, and Israel has to respect their rights.
So you mentioned the fact that politics and international law are blended, and in this respect, two things happened recently, one coming from Washington and one from The Hague. Let's start with Washington. It has been a long time policy of the United States, as you mentioned, Professor Kontorovich, starting with the Hansel memo of the State Department in 1978, that settlements were illegal. Recently, Secretary of State Pompeo announced that he disavows the memo, I think he said, and therefore settlements are legal. What difference does it make? And what happens if the Democrats win in November when Biden has already warned against moving ahead with annexation or applying the Israeli law? Professor Kontorovich.
Secretary of State Pompeo declared in November that the United States does not regard settlements as illegal. And then further, speaking at the Kohelet conference on the Pompeo Doctrine in January, he said he disavows the Pompeo memo. But it's not the case that it has been the long-standing policy.
The Hansel memo.
Hansel memo. It's not the case that the long-standing policy of the United States has been that the settlements are illegal. This was the conclusion of a State Department legal advisor's memo in 1977. That conclusion itself was repudiated by President Reagan, who declared the policy of the United States that settlements were not illegal, and that was never changed. So this was more of a clarification of existing policy, and indeed, even under the Hansel memo, the settlements would be legal today because of the peace treaty with Jordan. Now, it's true that this is a political decision based on a legal political decision combined with a legal decision, and it's very possible that a future administration could reverse it and say, no, now we regard them as illegal. Though it's important to note that Clinton did not, and Obama did not reverse Reagan's determination that they were illegal, so it's not so obvious. But even if that happens, I think that's a good thing in a sense, because it demonstrates that this is not some objective legal analysis as many pretend, but it is fundamentally intertwined with political positions. And it's one thing to say the settlements are for sure occupied, and the other thing is to say they're occupied if there's a Democrat in the White House and they're not occupied if there's a Republican. That makes it seem a much less clear matter of international law, and you can't have the sort of neutral appeal of international law in that case.
Pnina?
So I think again that the way or the recognition of the world is more a political issue. We have also a Security Council resolutions talking about the illegality of settlements. So I think it is the position of most of the international community that the settlements are illegal. I think that, again, this is indeed the prevailing, the more prevalent view. I think there are good arguments to say that, again, this is not exactly the legal question. I think that, and I also think it's not a very conducive, that it doesn't really help to settle the conflict, because I think that the better way is to see the settlements as an issue that both sides have agreed that should be negotiated in the permanent status negotiations and decided there. So when we go into the legal definitions and insist on looking at it as a legal issue, we are actually making the prospects of reaching a settlement more difficult, because from the Palestinian point of view, it makes it much more difficult for them to make concessions with regard to settlements if it's their legal right that the settlements are not there. And since I personally want us to reach a peaceful settlement and a separation, and I'm ready for the two-state solution, I think, but nobody really expects Israel to uproot all the settlements, including the settlement blocks next to the Green Line. And it just makes the focus on the legal aspects, and again, since the legal aspects are not really so clear-cut, I think is actually detrimental to reaching a peaceful agreement. And the international community's insistence on the legal aspect is actually, I think, actually making it more difficult for both sides to reach a settlement.
So what you're saying is that if we had a peace process, it would have made it easier in the arena of international law, because then it's a question of negotiations, etc.
We see it in Cyprus, by the way. Eugene is an expert in that. But when you look at Northern Cyprus, they're trying to reach agreements that are not necessarily implementing the law and uprooting all the Cypriots, the Turkish Cypriots that are living there.
Okay, so having a peace process might have been easier to defend Israel's argument in the arena of international law.
We saw that even when there was a peace process, which specifically addressed the settlements and related to them as a final status issue, this did nothing to temper the international community, much of the international community's description of them as illegal. And ultimately, the Palestinians made what I think was a choice to choose the international arena, the ICC, the General Assembly, where they could argue on legal grounds maximalist demands that would be harder to achieve in negotiations.
Yes, but the question is, okay, so we don't have an active peace process, but this move is unilateral. Wouldn't it make things even more difficult for Israel to defend its case in the international law arena?
Yeah, let me take the first crack at that. This move is partially unilateral in the sense that it is part of a vision for peace, which is designed to bring negotiations with the Palestinians and includes a heavy down payment by Israel to make commitments beyond Oslo, beyond what they made in Oslo regarding construction in Area C, to induce the Palestinians to negotiate. That does not look like it's going to work immediately, but this is not the first unilateral step. The Palestinians took unilateral steps when they sought statehood determination at the General Assembly, when they pursue ICC investigations against Israel. All of those are unilateral steps. So I think we're past the world of no unilateral steps. And Israel actually did not respond immediately to the Palestinians' unilateral step, but waited till many of them grew. I think it's very likely that if Israel annexes or applies its law to these territories, there should be an ICC criminal investigation of Israel. I think it's 100% likely. I think it's also 100% likely that if Israel doesn't apply its law to these territories, the ICC will investigate, because the ICC has made it quite clear that it's moving in that direction long before there was any discussion of applying Israeli law. So, after the fact, there will be an ICC investigation, but this does not increase those chances significantly, because it's hard to increase chances beyond probability of 1.
Pnina?
So I think that the annexation will make it more difficult for Israel in the international arena. I agree that the ICC is probably going in the direction of an investigation anyway. But I do think that it will add another layer of arguments and make it more difficult for Israel. It will also make it more difficult for Israel in the international arena in general, because of the I think wide opposition to such moves, and it could lead to Israel facing all kinds of measures. I don't know if sanctions, but measures that are maybe short of sanctions that will be detrimental to it. So I do see that there are costs in the international arena. I think there are also costs internally, because such a move could lead to it could go peacefully. We never know. It really also depends nobody knows what the annexation is going to look like. The map is a big question mark. So there's a difference between annexing just blocks of settlements and annexing all of Area C, or 30% according to the Trump map. There are different options here. I think if the annexation leads to violence, to clashes, to our soldiers again forced to fight Palestinians going into the towns, to the collapse of the Palestinian Authority. I'm not sure it will happen, but it might, to breaking ties with other Arab worlds, official, non-official ties. I think these are a lot of prices, the potential prices. I am not sure what is the gain from going ahead with the annexation. So I think that it's more a kind of internal political move that now is also facing internal political opposition from the right. So even if the internal political logic is less clear, and I think it's a move that I wouldn't be opposed to it if it was part of a wider attempt to redefine the situation, but also with giving the Palestinians more freedom, with helping them be more independent, whether the state or another entity, and also saying, okay, and we want to have a border, a clearer border, a separation, so we can both live peacefully next to each other. Then I would see the logic. But this way, I don't see what are the good things that will come out of an annexation.
Can I speak to some of the benefits that Israel?
Yes, please do.
So I think there are some benefits. Again, there may be some costs. On the question of costs, I agree with Pnina, we don't know. But the story we hear about a diplomatic tsunami, breaking of ties with the emerging ties with the Arab world, is also a story we heard about the US moving the embassy to Jerusalem, about the Golan Heights. and nonetheless relations with the Arab world continued to improve. There's reasons they would care about this less, actually. Jerusalem, of course, Al-Quds, very emotional issue. The Golan Heights was undisputably sovereign Arab territory before Israel took it in 1967. This is merely changing the rules under which Israelis are governed in the West Bank. So I want to say, and that is one of the main two benefits of this plan, I think, from Israel's point of view. The Israeli communities in the West Bank are all now under military rule. This was originally a measure designed because it was the whole situation was supposed to be temporary, because Israel expected in 1967 that the Arabs would, after their great defeat, immediately sue for peace, and then Israel has expected at many other points since then that peace would soon break out. So why apply Israeli law if you're going to have to unapply it? So it was supposed to be a temporary measure. Of course, as we know in the Middle East, nothing is as permanent as the temporary. So we have this very uncomfortable situation where just many practical things are difficult for the hundreds of thousands of Jews living there. For example, Ottoman land law is the law that is applied by the military authorities. Now, do you know any good Ottoman land lawyers? Most people don't, and it's quite hard. There's many problems with any kind of permitting, not just of building settlements, but of infrastructure work, roads, sewage, etc. Environmental law does not apply. And basically, all of this was held in limbo in the hope that the Palestinians would soon come to the table. And Israel wants to say, we can't hold these people's lives in limbo for no good reason, because the Palestinians are not coming to the table. Now, at the same time, to Pnina's point, I'd actually be less happy if Israel said this is part of a scheme. I think what makes this more defensible is Israel is not saying this is part of setting borders, because the map is going to look very weird and maybe not so useful as a map of actual borders. Israel is saying, until we get a deal with the Palestinians, we're going to normalize the lives of the Israelis. In any deal with the Palestinians, the borders are going to have to be both broader and narrower in some ways. So every peace plan, or as you know, since the Clinton parameters, has assumed areas under Israeli law are going to be transferred to the Palestinians by the form of land swaps. So the fact that Israeli law is applied is not the last word on borders, right? Israel may want more or less than this for its final borders, and nobody says that the Negev, the location of many of these land swaps, should not be under Israeli law until a final status deal, because maybe it has to be transferred. So those are some of the practical, but there's one more practical benefit. There is also a symbolic idea here that the presence of people is not a problem. That people should not be expelled as part of a peace agreement. And whether ultimately they're moved into the Palestinian side or not, their being there is not a problem. Again, as in the Cyprus peace negotiations, which don't call for the expulsion of settlers, East Timor peace agreement, which does not call for the expulsion of settlers. So if them being there is not the problem, let's not make additional problems for them.
Okay, correct me if I'm wrong, but I hear you, Pnina, talking about annexation, and I hear you, Professor Kontorovich, talking about applying Israeli law. Do I detect some kind of ideological inclination here, or it's just my sensitive ear? Pnina.
Well, the terminology, yes, usually if you are for it, you call it applying Israeli sovereignty. If you are not so supportive, you call it annexation. I think I was saying annexation because that's the terminology used by everyone, but I think annexation is a little bit misleading because it gives the feeling that it belongs already to a different state and we are annexing it. While as I said, it's disputed area, so maybe applying sovereignty is the more accurate term. But again, I think my issue is that even if we say we have claims for this territory, but I still think that the Palestinians also have claims for this territory. So
Okay.
my problem with unilateral steps is when the unilateral steps are only focused on the Israeli perspective and are not also trying to find a kind of solution, even if unilaterally by us, since they are not cooperating, but also acknowledging that there are Palestinians there, we need to also find a solution that will enable them to live a good life. So that's why I think there's something a little bit, so that the term annexation maybe fits it better. Applying the law, by the way, is the technique. the technique used to apply the sovereignty or to annex. There is the potential possibility of applying the law without trying to apply sovereignty or annexing, just as a technical measure. Say we apply the law for instead of having a military commander. That could be done also in 1967, but that's not the case. That's not what's at stake here. Nobody is talking about applying the law just for technical reasons to make life easier. The whole debate is also about the rationale of applying sovereignty. And when
this is what we've done in the Golan. I think we applied the law, but still negotiated it with the Syrians.
Because in the Golan Heights, there was otherwise a lacuna there. We would start applying the Syrian law, and there were not so many Syrian residents living there. There were, but not so many. So I think there it was more a kind of technical solution to have a legal framework. Here there is a legal framework. Most of the Israeli law is already applicable to Israelis living in the settlements through military orders that adopt them, or through personal legislation in Israel that includes them. And yes, as Eugene said, the land issue is different, but I think the petition or the judgment in the petition of the High Court of Justice from last week clarifies that the fact that Israeli law will apply won't make it easier to expropriate Palestinian land.
Yes, Eugene?
Yeah, I'm actually just walking around because I think somebody came to my door. Yeah, so let me just say very briefly, and then actually I have an unexpected delivery. The reason annexation isn't the right term, because annexation refers to territory of a foreign country, which it's not. Now, I think it is actually a technical measure, and it will be done as a cabinet decision. That is to say, it will not be done as an act of Knesset like the Golan law. Rather, it will be done simply by a cabinet decision. And so that's why applying Israeli law is a better term. Now, the problem with applying Israeli law is it's more than one word. So annexation is a term that often even slips out, or its Hebrew version, sepuach, from people who support it, because it's easier to say.
Okay, I'm sorry I caused so much trouble. and we salute your multitasking, okay, Eugene?
That once the Israeli law is applied, it doesn't matter if it's through a law or through a government decision. It does mean that any change, if we want later on another government wants to give back to to negotiate and give up part of the land where the Israeli law is applied, requires, according to Israeli legislation, either 80 members of Knesset or a referendum. So although this law maybe can be changed by 61 members of the Knesset, which is a question mark, but that means that it is tying the hands of future governments to negotiate these areas where the law will apply. So if it's just the blocks, that's one thing. If we start applying the law to every settlement in the middle of nowhere where it is very difficult to have that and a Palestinian entity, a functioning Palestinian entity, then we are making it much more difficult to negotiate in the future.
Okay, so we mentioned America, but there's Europe as well, and Boris Johnson just declared his opposition, and we had the EU also expressing their opposition to the move. Should we ignore Europe? Because last time, if I remember well, when we were about to sign Horizon 2020 with the EU, going back to 2008, I believe, Israel had to make some concessions regarding settlements because of the threat of the EU not to go ahead with this huge grant to Israeli scientists. Don't you expect difficulties with Europe on this?
I expect difficulties either way. That is to say, we can't pretend that the difficulties are just starting now. The European ambassadors or the European consuls in Jerusalem have an annual report that they publish listing measures that they seek against Israel. And they've been going down this list fairly fast. If there is a Democratic administration in the White House, they will probably go down that list faster. because it's impossible to pretend that Europe, they don't like the application of Israeli law, but what they see as the maintenance of the ongoing occupation and denial of Palestinian self-determination, that they'll be fine with. And how far they go is principally limited by internal European politics. The position of the European Union is unchanged, but many countries within the European Union have become increasingly resistant to its hostility against Israel, in particular the Czech Republic, Poland, the Baltic states, Hungary, and those countries are sure to block any very serious measures against Europe. And then one has to step back and consider the logic of it. So the logic suggests that if Europe is against certain moves, or if we need to take into consideration European diplomacy and their views when hostile to Israel's interests, but when there is a different wind blowing from America, we should still go with the lowest common denominator. So that's a kind of heads I win, tails you lose approach. And also, Europe also said they're going to do all these scary things about the Jerusalem embassy move and about the Golan Heights, and it turned out not to be. I'm not saying they're not going to do anything, but it's largely determined by, I think, their own internal factors rather than the specifics of what Israel is doing.
Okay, Pnina.
I agree with the last sentence. Eventually, every state will choose according to its own interests, but I do think that they will react. And one thing that is clear, that they will not treat the area that has been annexed or that the Israeli law has been applied to as part of Israel. So already we will have a built-in friction with regard to the applicability. We have it already today with regard to East Jerusalem, but it will intensify, and the Europeans might, at least each European country, maybe as the EU, Eugene is right, because the EU has to work in consensus, so as long as some countries do not agree, so as a bloc, they are more limited. But the different countries can make it more difficult to Israel, can start wanting to break down every agreement or every even commercial agreements or others that is done to make sure that they don't go to the annexed area. And then Israel will have to see whether it agrees to treat this area that it is just announced that is part of it as not part of it when it comes to these agreements. So it will put Israel on the spot. And I think, again, the reaction is also or the whole situation really, it is difficult to anticipate because, again, first of all, we don't know how much will be annexed, if it's more area, and if there are Palestinians living in this area, and if the Palestinians living in the annexed area will not get full rights in Israel, that would be an issue also internally. I think that would be problematic from a democratic perspective. As an Israeli, I would have a problem with that, but the world will also have a problem with that. And again, the response, if it really leads to a deterioration in the situation, to a rising violence that will lead eventually to Palestinians being killed in clashes with Israeli forces, I think that can put Israel again on the spot with more pressure from around the world. And if the US administration also changes and is not that supportive and will not block by vetoes decisions, so Israel could find itself paying a big price for a step which is not such, I think, despite what Eugene said, which the benefits of which are not so clear.
Last question is about the International Criminal Court. The prosecutor Fatou Bensouda is pushing a war crimes probe against Israel or Israelis. What does it mean practically, and can the move to annex, apply the Israeli law, make things even more difficult? Eugene.
Yeah, I think it's very hard to turn the dial past 10. I think every indication suggests that the prosecutor sees the actual existence of these settlements, regardless of what the law that applies to them, and the building of every balcony in Gilo and Eastern Jerusalem as a war crime, and that she seeks to pursue full investigation. Her position is actually quite remarkable because in her last report, she makes an annual report of what she's doing. Her last report in November made it quite clear that she sees these as war crimes that she is very likely to investigate. Also, at the same time, she concluded, as I mentioned before, that Russian settlers in Crimea, who are growing at a much larger rate, are not war crimes, and she did not really explain why. But this process, I think the train has left the station, and the ICC has been constantly used as a tool to scare Israel from taking particular actions. but I think the actions are going to be exactly the same, whether Israel builds more settlements, builds less settlements, applies Israeli law. In the area of the prosecutor and the time period the prosecutor regards herself as having jurisdiction, there have been, in her view of the matter, more than enough crimes committed, and she has all of the internal political backing needed. So we're being sold the same horse twice.
Pnina.
I agree that the prosecutor seems to have made up her mind with regard to settlements themselves being war crimes. I think Israel has a good counter argument on the legal front with regard to the war crime of settlements, which I don't think is a customary war crime. But annexation, and especially if there is harm to the rights of Palestinians. Again, I will go back to the judgment of on the regularization law. A law like that expropriates private property, that goes into crimes that are much more defined, much more difficult to answer. So I think it can make a difference in what we will face there, how well will we be able to make our arguments, and also on the support of different countries. When we had now the issue of the jurisdiction, we had some states issue amicus briefs in support of the Israeli position that Palestine is not a state, there's no jurisdiction. And this support is important because we already saw that the ICC is also, the political arena around it does impact what happens there. So I think if we have less support of countries around us, including potentially also the US, if there's a Biden administration, but Europe and other countries that have supported us, I think this is also would be detrimental for Israel.
Thank you so much, Pnina Sharvit-Baruch and Professor Kontorovich. I'd like to thank my colleagues at JPC, Talia Dekel and Rachel Exil, for their contribution. Stay tuned to our next webinars next week, focusing on the American-Israeli angle of the issue with Ambassadors Dan Shapiro, Itamar Rabinovich, and Eran Lerman. Thank you all for being with us, and good day.
Thank you.